The 6 conservative justices on the Supreme Court okayed death by technicality on Monday. The case, Shin v. Ramirez and Jones, centered on the issue of a Sixth Amendment right to adequate legal counsel, and if someone is allowed to challenge their state conviction in a federal court by introducing evidence for the first time that their lawyer sucked ass, that they did the job so bad it violated their constitutional rights as a defendant. Here's where the problem starts. An anti-terror law passed in 1996 raised the bar exceedingly high for defendants trying to challenge their convictions. One provision of it forbids them from raising evidence during a federal appeal that wasn't previously heard during the state trial and state appellate review. Now, this could be a problem for defendants, particularly indigent ones who were provided counsel by the state. This could be a problem if they didn't receive sufficient counsel and thus were convicted, and then on appeal didn't get quality counsel again. In that situation, under a future federal review, the defendant would not be allowed to bring up a Sixth Amendment ground for a retrial. That's the exact scenario facing Ramirez and Jones, who this case is named after. They are both facing the death penalty in Arizona. Now, in the case of Barry Jones, his attorneys failed to introduce evidence that would have likely exonerated him in the rape and killing of his girlfriend's 4-year-old daughter. 22 years after his conviction, that evidence was finally brought forth in a federal courtroom, and a judge ordered the conviction overturned on the basis that failure to provide such evidence in the original state trial was a result of ineffective counsel. But the state of Arizona fought back and claimed that Jones should never have been able to bring claims of ineffective counsel because he had already missed his chance to do so, even if it was true that his lawyers were bad. Heck, even if it's true that his lawyers were so bad that an innocent man is now facing execution. Sorry, just can't show up a state judge like that, so off to the electric chair for you. Arizona lost their appeal before the Ninth Circuit, but the state has now won before the Supreme Court. In fact, the court is overturning a prior case it ruled on in 2012 that gave convicted individuals the right to bring Sixth Amendment challenges for the first time during federal appeal. That was ruled on 7-2, and it's now been overturned 6-3. The majority opinion claimed that, quote, a prisoner is at fault even when state post-conviction counsel is negligent. The minority on the court dissented. Justice Sonia Sotomayor wrote, quote, the Sixth Amendment guarantees criminal defendants the right to the effective assistance of counsel at trial. Today, however, the court hamstrings the federal court's authority to safeguard that right. The court's decision will leave many people who were convicted in violation of the Sixth Amendment to face incarceration or even execution without any meaningful chance to vindicate their right to counsel. Arizona Attorney General Mark Brnovich, who spearheaded the Supreme Court challenge, reacted to the ruling with this tweet, quote, I applaud this decision because it will help refocus society on achieving justice for victims instead of endless delays that allow convicted killers to dodge accountability. Or allow the state to kill innocent people based on technicalities in the law. Nothing should surprise us anymore coming from this Supreme Court. But upholding state-sanctioned murder of likely innocent people simply because they had a shitty lawyer? Not a good look. Hey, thanks for watching. Hit the subscribe button so you don't miss any of our new videos. Also, if you want to see Means Morning News in its complete form, not just the clips we post here, head on over to Means TV and get access to all our new episodes and our entire backlog. Plus tons of other great movies and original TV shows.